Good afternoon, everybody. If we can please come to order. Welcome to the Senate Judiciary Committee. We have a pretty lengthy agenda this afternoon, so we're going to get started quickly. Let me start, as we always do, with a word of prayer, and Senator Hatchett told me he felt inspired, so I'm going to let him open us up.
Well, thank you, Mr. Chairman. Let us pray. Dear Heavenly Father, we thank you for letting us gather here tonight. Thank you for getting us here safely. Please return us home to our families safely. Please watch over us and guide us as we make the laws for the people of the state of Georgia. In Jesus' name I pray. Amen.
Thank you. All right, as always, if you want to be heard on a bill, please come up here and sign up on the sign-up sheets. We're going to collect those. We're going to somewhat stick to our agenda with a couple slight modifications. But with all these bills we have in our stacks, if nothing else, it keeps us on track to kind of follow our stack. That said, let's throw all that off, and we're going to start about halfway down as a personal favor to, let's start with Representative Collins, Chairman Collins, House Bill 1150. If you want to give us a second to get everything sorted and come on up. And we are working, here we go, off of LC 394165. Is that what you have?
Yes, sir.
Before I do that, Judge Brenda Weaver's back with us again. Where's Judge Weaver? Good to have you back with us again.
I'm so tall, it's hard to see.
That's all right. Thank you for joining us from the Appalachian Circuit. All right. Mr. Chairman, the floor is yours.
All right. Thank you, Mr. Chairman and members of the committee. I bring before you House Bill 1150. This came about from some conversations with our friends at the Sheriff's Association, and one of the House members called me during the interim, and he said, hey, my sheriff has called and said that violation for a window tint is a fingerprintable offense. I said, well, I'll have to do a little research and look into that. And so I talked to the Sheriff's Association, and they confirmed that and got to digging into the issue, and seems that this violation was put under in the Attorney General's office as a charge that was fingerprintable, but no one that I've spoken with, any jurisdiction, is actually taking fingerprints for those who are accused and charged with violating that statute. And so all we're doing is simply removing that from the statute that was set up through the AG's office. So,
all right. Questions from the committee? All right, nobody signed up to speak on the bill. Maybe you're right. This would be quick and easy. We'll see. What's the pleasure of the committee? Motion do pass from Senator Couser. Do we have a second? Second from Senator Hodges. All those in favor of the motion, please raise your hand. It is unanimous.
Thank you, Mr.
Who's
Chairman.
going to carry the bill in the Senate?
Probably Senator Bearden.
Senator Bearden. All right.
Okay.
We'll see if he can pull that off. Maybe his first bill.
Maybe.
That'd be a good one. Yeah. Should we add anything about billboards in there as well, or?
If it's the pleasure of this committee to amend the bill, then
good
go
answer.
right ahead.
There's always time for a floor amendment. So
thank you very much.
All right, thank you. All right, we're going to go back now to the top of the agenda. Chairman Smith, House Bill 827.
Good afternoon, Mr. Chairman.
Good afternoon. One of my colleagues on the other side of the committee and of the two committees in the House. Good to have you with us.
Yes, sir. Good to be with y'all. I can do a brief chairman's report. We have moved several Senate bills so far, so we're trying to do
several
on the other side. Yes, sir.
Well, what do you call? Let's see. We moved 14. Yeah, well, total, but I'm talking about just in the last week. Yeah, last week. So, someone told me earlier, I think we've got 20% of all the bills that y'all pass are actually in this committee. Isn't that kind of crazy? It might be an exaggeration, but there's a lot of them.
I think we've moved 3 to 4 so far with just one meeting of the subcommittee in full, Mr. Chairman.
Well, you do good work.
Well, likewise.
Yes, sir. Well, tell us about House Bill 827, working off of LC 560167S.
Yes, sir. This substitute, and I'll go over each section just very briefly. Section 1 was requested from our good friend Commissioner Harper at the Department of Agriculture. Apparently, we had left out years ago a simple change there that you see with inserting Title 16, several places there within Section 1 of the bill, and what that would allow is for them to actually have the power, as long as there's an agricultural nexus to crimes being committed involving livestock. For instance, theft of livestock, there's actually an investigation ongoing right now to give them the proper authority. I know there was a big bust of a meat processing plant within the last couple of weeks that resulted in actual illegal activity going on there. No meat processing was going on at all. So that provision will give them the proper power to where they could help in the investigation, arrest, and subsequent prosecution of those crimes, as long as there's an agricultural nexus, and make sure that in the process of that wouldn't be challenged and thrown out by our courts here. Section 2, this is one of the new provisions here. This is dealing with a problem that we've seen come up here at the zoo. You have a lot of folks, for whatever reason, misguided as it may be, they like to jump into these animal exhibits. Well, if you kept up with Harambe years ago, they had to put Harambe down because of the events that occurred there. So that's just a good example I like to provide with everybody. This would actually make sure that we have a crime of trespass that deals with trespassing in these exhibits. Could also be another, I guess you could think of a petting zoo with a wild animal. I would proffer that would cover them as well. So that's what Section 2 deals with here. And then finally with Section 3, this is the original part of the bill, and that is dealing with theft of livestock. If any of y'all from rural areas or may have grown up in rural areas before, I know the chairman's got a farm and his family as well. The price of livestock has increased tremendously since the war with Ukraine. If you'll recall, there was a ship that was hit by a ballistic missile in the Red Sea just over the weekend, or the last few days rather, and it was filled full of fertilizer. Fertilizer prices have gone up, so we've seen the prices of livestock go up. I also have an example of, let's say that you've got one of those $100,000 seed bulls, one of them souped up bulls like Mr. John Calloway would have. When that bull goes missing, that's a big chunk of change to replace. Not only for the big producers or the $100,000 seed bulls, but also for small family farms that we see a lot here in North Georgia, north of Interstate 20, I would offer as an example. A lot of those may not have within their insurance the coverage to replace that. And so not only are they out the price of whatever that bull, calf, cow could be, heifer, whatever that price is, they're out double the money. And so this is a big deterrent part of this language that we hope will provide the necessary relief. I know there's actually a couple of active investigations going on right now. A lot of livestock theft happens in transit at sale barns. Thankfully, Chairman Perkle helped with legislation to deal with checking livestock ownership many years ago. But now we feel like this is the right time with beef prices increasing, chicken, pork, all the above, that this is needed to help deter those who would steal livestock. So, Mr. Chairman, that's the basis of the bill.
All right, you have some questions, Senator Cowsert?
Thank you, Mr. Chairman. So Title 16 that you're giving the Ag Department ability to enforce, that's the entire criminal code.
Yes, sir.
So we're going to create a new police force?
No, sir, that's not my understanding. That's to allow them to go in and help with the investigation. If need be, they could have that arrest power, and it's also a clarification. Arguably, Chairman, they already have that power. This is to try to tighten up the language in the other code section to make sure that these investigations that they may initiate or they may start, which that could be investigative, arrest, and coming to subsequently testify, that it's not thrown out on a technicality, making sure it's uniform across the code as is.
We just passed the a hemp bill out of my committee in the Senate, and we amended the bill to make clear that it only applied to chapter whatever of Title 16 on those type of offenses. This started this same way, that it included the entire criminal code, and I just wondered if that was your intention.
Yes, sir, it was. I mean, it's hard to try to give every hypothetical. I know you and I deal in a lot of hypotheticals in our line of work, but we wanted to make sure that we gave them the authority we needed so that when crimes are committed, we're not having to come back, wait until our 40-day session next year to come back and give them the proper authority. That bust that happened on the meat processing plant, I think there was a little over $20 million of marijuana seized there that was going on there. So to have them be able to come in and identify that crime in particular, we would hope to be able to accomplish that and give them more authority to where they could have a little bit more of a leading role in that whole process under this bill.
Senator Watson?
Yes, sir. Thank you. Just clarification. So at times of emergency or when they're helping other officers, doesn't that just give them the ability to do or to assist other officers in the field kind of thing? Doesn't necessarily would be trying to get out of their jurisdiction, but more from an aid standpoint. To me, that's isn't that sort of what we're giving them the power to do?
Yes, sir. That's included in there as well. And exigent circumstance come to the aid of those to help even in detainment. That would be covered under here as well.
So I just have a couple questions, and really relating more to deer hunting. And some people enjoy that, and I know when I was in the House that deer baiting, though I don't consider it baiting, but that was the term that was used. So if we look at Section 2, I mean, I could read that in there, that deer are wild animals, and you are feeding them. And there's certainly, you may be feeding them as the likelihood of injury, i.e., dry powder or bow and arrow or a gun. Does this criminalize that? I mean, I'm just stretching that maybe, but that's sort of what we do on Judiciary, hypotheticals.
That is not the intent of the legislation, Senator.
I wouldn't think so.
And so I wouldn't necessarily read it to be that way. However, I know how the things we do here can be interpreted the wrong way, and we have to get out the crayons and coloring books for those that might interpret it. But a good point, Senator, and if you would want to offer an amendment to tighten that up, I would take it as being free.
I'd sort of have to defer to legislative counsel, and I could also look at it from, in our neighborhood, we have folks who feed the deer at 5:30 every afternoon, and the deer congregate, and it's a little bit of a nuisance for the other neighbors, especially when you're driving your car around. So I'm wondering, I just don't want to make something illegal that is clearly legal. But
yes, sir.
I'm just throwing that out there. If I'm the only one in the world who sees it that way, then I'm good to let it go. But
yes, sir. And I would say, Senator, I appreciate the point and the line of questioning there as far as these animals to make sure that we understand the intent behind these provisions. These are for those animals that are exhibited for viewing by the public. So if you're just feeding a deer in the backyard and you raise up your fences like you see on the side of the interstate, my understand the intent of this is not to have that covered under this provision. This would be for those that are for public viewing.
If you look at line 68 through 71, you've got to actually enter a cage, enclosure, or other area wild animal is housed or otherwise contained in which the person has no legal authority to go, and then harass. So the harassment of itself would not be a crime. Harassment, you're reading the definition of harasses, but you also have to illegally enter an enclosed area where a wild animal is contained.
okay, all right, that sounds great. Stand corrected. Move do pass.
Well, not yet. There might be other concerns. I don't want anybody reporting that we made it illegal to feed the deer in your neighborhood, or illegal to feed them then shoot them after you feed them. But any other questions from the committee? There are a couple people who want to speak on the bill. All right, I'm going to call up first. Let's get the other page. Thomas Weaver. Yep, Thomas Weaver. You want to come up? Good afternoon.
Good afternoon, Mr. Chairman, members of the committee. Listening attentively to what Representative Smith had to share, sympathetic to the plight of the author. I agree. It's not okay. This behavior needs to be criminalized. And the General Assembly certainly has a legitimate vested interest to define crime and affix punishment. Looking at Section 3 of the bill regarding the raising the penalties that would be incurred by a criminal defendant if the criminal defendant is lawfully arrested for, duly charged with, and properly convicted of the offense of livestock theft. The author proposes through legislative counsel to raise the felony penalty 200%, 150% on the high end of the scale there. Multiply the fine factor by 10, and then elevate the misdemeanor to a misdemeanor of the high and aggravated nature. The thing that I wanted to share with the committee, and I don't know if this is exactly how the theory works in the court of law, but under the rule of lenity, this was an issue that I raised. I want to share it again publicly. Under the rule of lenity, as this committee is more than well aware, and I trust many in the audience would too, when there's two statutes that define crime and affix punishment, the courts tend to skew under a rule of lenity argument in favor of the defendant. Generally speaking, under Georgia's theft laws, if you look at Chapter 8 of Title 16 of Volume 14 of the Official Code of Georgia annotated, where this code section is cabined under, 1500 is the misdemeanor felony divide. You may recall those criminal justice reforms that was done a few years ago. That 1500 number is the number where a theft becomes a misdemeanor or felony. That's the line. I believe you'll find that under Georgia Code Section 16-8-2, and if you look, it'll point you to the penalties through there. That 1500 number is important because you're keeping that 100 threshold here for animals. Now, I'm not a farmer. I don't know how much a sheep cost or a cow cost or a horse cost. I'm not looking to take any of those animals, obviously, and I hope no one else would either. But I can imagine that some of those animals might reel in a fair market valuation more than that 100. But there might be an instance in respect to a select isolated hypothetical criminal defendant where an animal that's wrongfully taken or wrongfully misappropriated from a farmer might be just under that 1500 threshold. And if so, could they, through skilled counsel, it's just, again, for sake of the argument, while the committee's looking at these punishment provisions, could they, through skilled counsel, say, wait a minute, rule of lenity issues here because the Georgia General Assembly has specified a different area of the law in the same chapter that says if it's less than 1500, which is the newer of the two provisions, and there's also a law there too. You know, when the Georgia General Assembly has two laws that conflict, whichever one's younger prevails. So the criminal justice reforms tend to be more recent. So could there be a rule of lenity issue there? And if so, Mr. Chairman, members of the committee, seeing as how these penalty provisions are being raised to the extent that I alluded to when I first started my remarks, would it be cognizant of the committee to consider on that last line there, I think it's lines 100 through 103, looking at that $100 valuation, maybe it should be a higher number, maybe that 1500 to kind of jive with what the General Assembly has said elsewhere under the chapter. I don't make public policy decisions, obviously, Mr. Chairman. It's just a thought, and I wanted to raise it because if the intent of the author is to go after those who would steal the farmer's animals, which he should do, and it's not okay, would he be left frustrated, and would his proponents be left frustrated if the courts were, through the judiciary, were to decide, hey, wait, because of rule of lenity, in that hypothetical instance, there's a conflict here, and it defeats the purpose that the General Assembly is trying to accomplish without looking at that further.
You want to comment on that?
Just real briefly, Mr. Chairman, I appreciate my friend's learned answer here, although I would say that the rule of lenity would not apply here because the theft statute differs from the livestock theft statute because the theft statute does not include livestock. That would be the defining element here within this statute, and so therefore, Mr. Chairman, I would submit to you that this would not run afoul of the rule of lenity.
If I may speak, Mr. Chairman, I'm not arguing with the author from the table. Looking at the definitions, it says property under the chapter and under the, you know, when you take any property. So, if livestock is property, it's just a thought. Just a thought.
All right. Thank you. We also have any questions for Mr. Weaver? I'm sorry, from the committee. All right. We also have Brian Hudson from Zoo Atlanta. Will you reassure us that Senator Watson can still feed the deer? Yeah.
Mr. Chairman, thank you. I'm not even sure I know what to say. Thank you so much. My name is Brian Hudson. I do represent Zoo Atlanta. I want to thank Chairman Smith for bringing this bill forward, and I think we addressed Dr. Watson's issue, and I agree with the author on his assessment and yours as well, Mr. Chairman. So we support this bill, and really the biggest issue for us is we've had some incidents at the zoo. Fortunately, we haven't had any attacks or deaths, but we're hoping that this will deter these type of activities moving forward. There has been zoos and aquariums in other areas, safaris, et cetera. There has been attacks, and human life has been lost, and the animal's life has been lost. So we're hoping that this will deter that type of activity. Thank you.
Any questions for Mr. Hudson? You do have a question, Senator Parent?
Thank you so much, Representative. And to my friend Brian, what status of this wild animal piece? Was it in the House and didn't make crossover, or did it just come up now?
It was introduced in the House. It was added to another bill, and the subject matters were interesting. So this was a better fit.
Oh, I see. Okay. And then, so out of
It was
curiosity,
House Bill 61, is that right? Is it the 1361?
Yes, correct.
1361,
So it's on
okay.
another bill, but it did pass the House unanimously.
So out of curiosity, the language about how the animal, like, so the person goes in the enclosure, bad. Okay, I get it. But then it says, I mean, I understand why it wouldn't be an affirmative defense to injury of the animal, that injury was necessary to protect the person from injury or death. But it does sound a little odd, like in the sense of it's pretty harsh. But if you could just speak to that for a minute.
Do you want to address this?
Thank you, Senator. It's good to see you again. I think this is one of those common sense times. You've got a wild lion from the Sahara, or from let's say Congo, and
Let's see.
I mean the common sense part is like you ought to know better than to go into a cage with a lion, and so that's really the reasoning behind this, as far as why you don't have an affirmative defense here. That was really the emphasis behind it, as I understand.
I mean, you should not go in a cage with a wild lion.
Yeah. Or a silverback gorilla, hyenas.
And many of those
Yes,
beasts.
Tasmanian devil.
Thank you.
Mr. Chairman, if I will.
If you must.
If must, excuse me. If I will. Forget it.
Senator Jones?
My question was along the same lines, but I guess the question was about it then being a felony, because the person probably doesn't have, there may be something cognitively wrong with them by going in there, and the animal has to be killed so the human being won't be killed. Okay, he's going to suffer some punishment, but the felony punishment, I think, is the question that we're kind of having. Why a felony?
I think in your example that you gave us in that hypothetical, and thank you for that, Senator, I think you would find that the insanity defense would be available there. And so you would have the defense there to supply that need and that certain hypothetical that you just presented to us.
Senator Cowser.
I'm sitting here I'm agreeing this is pretty harsh to make this a felony. I'm old country boy. I'm thinking about cow tipping. You just made it a misdemeanor if you do it and the cow doesn't get hurt, and you made it a felony 1 to 10 years if some high school pranksters do that. I'm having a hard time realizing how big of a problem this is with people harassing wild animals. I mean, are they breaking in zoos all over Atlanta and scaring little critters, or what's going on?
what's happening, I think the best example, Chairman Calzert, is not necessarily here in Atlanta, but there was a situation 2 years ago in the Naples Zoo in Florida where a gentleman had the illegal authority to be there as a worker. I think he was cleaning just the restrooms and stuff, and decided to jump over the enclosure and stick his arm into a tiger's cage, and the tiger ripped his arm off, and they shot the tiger. We have not had those situations here in Atlanta, thank goodness. But this is actually more widespread than just the Atlanta Zoo. There's actually a new facility actually opening up in the chairman's district here this year, Conservation Park, and we've got supporters all around the state at various facilities from Wild Adventure and Valdosta. But we're hoping that this is a deterrence, that people won't feel like they should go into a lion's enclosure, and it's happening. It sounds crazy, and we're all kind of laughing a little bit about it, but it really is happening, and it seems to be that the folks that are doing it are doing it. We've had a situation where some folks wanted to pet elephants. We've had situations where somebody wanted to take a picture with a lion closer to them, and fortunately they got out before anything tragic happened. So it's, again, we're fortunate here. I think nowhere in Georgia has this happened to the point where there's been death. But these animals, a lot of them are endangered, and a lot of them are becoming endangered, whether it's some of the rhinos or some of the tigers that we have. And so it's an unfortunate situation that common sense shouldn't dictate that you shouldn't do this, but that's kind of why we are bringing this forward, because it's happening.
And the only thing I would add is cows wouldn't be considered a wild animal.
That's what I wanted you to clarify.
Even though I would argue, Senator, those Charolais, every one I've ever seen, are crazy as can be.
Bulls might be.
So,
Line 63, they can't be a domestic animal or livestock. And line 64, they have to be housed at a facility with a certain purpose for public visitation, conservation, education, or science. So cow tipping, still good to go. Well, until Commissioner Harper gets after you, but we'll leave them alone. Senator Setzler.
Thanks, sir. Appreciate this. Unpack this. This is making sense to me. And I appreciate the Zoo Atlanta's efforts on this. I think it's a good step. My question was, as you unpack this, animal sanctuaries. I mean, I think, we might have I have an idea of what some of those could be, and it seems appropriate. But we just step outside of that. Bird sanctuaries. Are there areas in Georgia, the entire area is designated as a bird sanctuary? I think about myself or people, young people walking around with a BB gun. If a kid with a BB gun shoots a wild bird in a bird sanctuary, in a geographic area that's called a bird sanctuary, are we getting? I know that's not your intention. Are we getting into felony land by doing that? And how are bird sanctuaries defined in Georgia? And I think about a bird sanctuary. There may be, and are there animal sanctuaries? And I don't know the answer. This is a real question. How broadly are those defined, and how exclusive are they? Because if someone going into a birdhouse, for example, that's got an aviary, for example, and you're trying to kill these animals. I understand that's what you're trying to do. But are there geographic bird areas designated sanctuaries that could get someone into felony land?
I'll just preface before I respond that Lieutenant Governor Pierre Howard would be very proud there's a state senator that loves birds as much as him, as it sounds as if my fellow South Carolina higher education grad does. I would say that I'm not aware of many of those. Callaway may have something of that sort, but as far as them being even close to this, I mean, you got to think as far as bird sanctuary and how large of an area that would encompass. If somebody's on those premises that is not there to just view, or they actually run afoul of this statute, then yes, that would be a criminal conduct that would need to be prosecuted if they're trying to mess with these birds. I would think that you would have plenty of signage there, especially if it's a public a place for public viewing of these birds, that you would have those requisite barriers and signs that clearly indicate these are endangered birds, like if we had a condor or something.
I mean, are we going to get into a place where, I know it's not your intention, we're going to get into a place where, in some land in conservation easement, somewhere in the language of the conservation easement agreement, it's designated as sanctuary. All of a sudden, I got 6,000 acres in a rural county that's designated sanctuary, and I shoot a crow or a squirrel, I'm in trouble here. I know that's not your goal. I just don't know how these things work.
I think it's shooting the crow on that sanctuary property.
Yeah, so if there's 6,000 acres, it backs up to my granddad's property, I'm walking around with a BB gun, I see crows and squirrels, and I know there may be people here think I'm being callous to suggest that's, I'm just saying it. If kids do that, are we creating a crime? And I don't even know the answer if conservation properties are designated as sanctuaries. I just don't know what sanctuary means. That seems like a big word. So it may be something we can discuss moving forward. I just wanted to raise that as a concern. A lot like your bill.
Mr. Chairman, you mind if I address that? Thank you, Senator Setzer. I think if you look at lines 62 through 67 as it relates to wild animal, the purpose of public visitation, so the crow wouldn't be for public visitation, conservation, education, or science. So I think that's a pretty critical piece that probably wouldn't, in my opinion, wouldn't fall under that particular scenario.
So if it's the species that's designated for preservation, that's what gets you into trouble, is what you're saying.
I think it falls under the public visitation piece. As I said, in one of these, the zoo or an aquarium or a safari park, things like that of those nature.
But again, so a facility operating with the purpose of conservation. I understand public visitation, I understand education, I understand science. My concern is the conservation. That's why I used the example of that's an example of a conservation easement or some kind of permanent. You sell development rights to go in our forest land preservation program or something like that. I just want to make sure we're not tripping ourselves up.
I mean, is your hypothetical on this sort of property where somebody's on it trying to shoot this wild bird, this protected bird?
Not a protected bird. I'm talking about an unprotected bird, but on a property that's a conservation property. I mean,
Okay,
if this is a red cockaded woodpecker, it's already preserved. It's already protected under other statutes. If this is a circumstance where if it's a sanctuary for a certain kind of wildlife, I get that. But I'm just asking the open question: do we create issues in conservation properties? But with that, Mr. Chairman, I'm done.
I would say to my friend who graduated from Furman that would not be the issue. And
You had to go there.
Chairman Calsert, I apologize. You've been a Presbyterian grad yourself, so I didn't want to leave you out there just as an aside.
That's very kind.
All right. Nobody else has signed up to speak on the bill. Commissioner Harper, do you want to add anything? I didn't recognize you. Thank you for being here with us. I don't know if you care about the cow tipping or the deer feeding or the wild blackbirds.
I'd be happy to, Mr. Chairman. I appreciate it. Obviously, being a rural boy, growing up on a farm, I do cow tipping is. I appreciate Senator Calsert bringing that up and that concern, Senator Calsert. But I believe it's Section 1 and Section 3 of the bill is what we're interested in. Specifically, I'll talk to Section 3 really quick. I think Chairman Smith laid that out very well in saying that the price of cattle is significant today, and arguably the penalty in current Georgia law doesn't match up with where we are in the livestock market. So this helps give that additional penalty to match us where the livestock markets currently are. In relation to Section 1, I just want to clarify, the Georgia Department of Agriculture does have law enforcement authority. So we're not creating a new police force. We're not creating a new law enforcement entity. The department is authorized to employ post-certified law enforcement officers to effectuate agricultural laws of this state and to carry out help carry out those duties. And specifically, the commissioner is tasked to investigate and protect the welfare of livestock, animals, farmers, and consumers in this state from a variety of issues. I think Chairman Smith laid it out well in stating that we've been working with the Prosecuting Attorneys Council since we reinstated the Law Enforcement Division. It was dismantled a few years ago by a previous administration, but in prior years, the entity did investigate cattle theft. They did prosecute those cases. And so in our conversations with PAC, especially now that we have a statewide animal abuse prosecutor that works with PAC, those animal cases are specific to, animals are one of those things that we have jurisdiction over at the Department of Ag, and we do investigate animal abuse. Matter of fact, under Title IV, we have certain authorities already under current law that give us the ability to investigate those cases. But if they get into a criminal nexus, unfortunately, it's not clear that our authority gives us the ability to move forward in working with that statewide prosecutor to prosecute those cases such as animal abuse. So this is to clarify the law, to ensure that we have that clarity. So when we exercise those cases, that our law enforcement officers in those cases can withhold and upstand in the court of law. I think just pointing out a few things. I know Chairman Smith mentioned cattle theft case. We are at the request of a local sheriff's office, and matter of fact, we've been requested by local sheriff's offices all across the state to help. I appreciate the partnership we've already built with local law enforcement, both sheriffs and police departments, as well as federal and state law enforcement. We've been doing some joint investigations with federal, state, and local partners since the division was reinstated. Right now, we're in the middle of a cattle theft case that goes over multiple counties and actually multiple states, and we're looking at upwards of $1 million in theft already. It's akin to a Ponzi scheme, and so our officers are investigating that case. We investigated a pecan theft case that was handed to us by a local sheriff's office. We did the entire investigation. We wrote the warrants, but we then had to go back to the sheriff's office, and they had to actually execute the warrants. Our officers could not do that because we were not sure that the law gave us the clarity to do so. Chairman Smith mentioned the most recent food processing case that we were requested by that local sheriff's office to help them in that case. And so we went and investigated that because food processing facilities fall under the jurisdiction of the Department of Agriculture. And because of that, it was found that they were actually not processing meat as they were perpetrating to be, but in fact, were growing significant amounts of marijuana. And so I think those are perfect examples of where we've worked together, but examples of why our agency, we just need the clarity in the law to ensure that our law enforcement officers don't get caught up in an issue where we're executing our authority. And I think it's clear, Chairman Smith made it clear, that it has to have an agricultural nexus for us to execute our authority under that code section. So it has to be within the confines of agricultural law. So if it's outside of those lines, we wouldn't have the authority to execute that authority. I also just want to point out, just for the committee's information, current Georgia law under Title 40 actually gives our officers the authority to execute anything under Title 40. So our officers can execute all laws under Title 40 currently because of the way the law reads. And so in other words, our guys could execute some of those provisions under Title 40. We're not planning to be that new state police. That's what the Georgia State Patrol does. But I think it's interesting that we have that authority, but I can't execute a cattle theft case, which truly does have that true agriculture nexus for the Department of Agriculture. So, Mr. Chairman, I appreciate the committee's willingness to look at this. I would appreciate your favorable consideration. I think from a safety and security perspective, as well as giving our officers so they don't take a chance of violating their oath of office or the oath that they're prescribed by law, that they're able to execute their duty every single day. And specific to those agricultural laws and protecting agriculture in this state, it is a national security issue, and I'm happy that we're working hard every day to protect the agricultural interest of the state of Georgia. I appreciate Chairman Smith's work, and I appreciate you listening, and I'd be happy to answer questions on anything related to the cattle theft provisions or what we're asking for clarity in the law.
Any questions for Commissioner Harper? Senator Rhett?
Thank you, Mr. Chairman. Where's your hat at?
I don't have it today, Senator Rhett, so thank you.
Any other questions? All right, thank you. That's everyone that want to be heard on the bill. What's the pleasure of the committee? Motion do pass by committee substitute Senator Setzler. Do we have a second? Second from Senator Hatchett. Discussion, Senator Cowsert.
I'd like to propose an amendment.
All right.
At lines 17 and 24, where we add in Title 16, I'd like to make it more specific, so it would be capturing Section 3, which truly is the purpose of the Ag Department to stop cattle theft. Make it reference Code Section 16.820, which is addressing cattle theft. My fear is that the entire Title 16 is a criminal code. I think that's far too broad and putting too much of a burden on the Ag Department.
So you would like to limit Title 16 to just be Title 16.820? Is that
Right.
the only area it would apply?
Yeah, I don't know the exact chapter that would be, but that's the code section that's added in Section 3. I don't think they care about enforcing people messing with zoo animals. That's probably not necessary for agricultural people to do. It said not livestock, so that's clearly a little something that wasn't in his original bill. So just narrowing the scope of the criminal powers. I do recognize that the Ag Department does have criminal law enforcement powers in certain agriculture areas, and we just granted them more in hemp regulation, but that's my amendment.
Let's see if we have a second for the amendment, then we'll talk about language for it and have discussion. Is there a second? We have a second from Senator Watson. Ben, how would we word that language so we have an amendment to look at?
So
Use your mic so everybody using that mic. There you go.
So, as I understood it, you want Chapter 8 of Title 16, which is all offenses involving theft.
No, I want this code section that starts at line 97, 16.820.
Okay,
So it's
just
Chapter
codes-
8, Section 20. I just didn't know what. I know it's in Title 16, but sometimes they have different articles, and I'm not sure where that falls in the code.
Well, if we're referring to a specific code section, we can just say Code Section 16.820.
Yeah,
So if
that's my
that's what you're
amendment,
interested in, then it would replace, just for the ease of amending, replace the 16 on line 17 and 24 with Code Section 16.820.
That's right.
All right. The author want to comment?
Just real briefly, I appreciate the chairman's concern there. The only thing I would say is that if we limited it only to 16-8-20, we couldn't deal with animal cruelty. If somebody's out there and got 10 horses on 5 acres and they're skin and bones, then that, I would argue, would be something that we would want the Department of Agriculture to be involved with. Because just because a horse shows its ribs, it may not be animal cruelty, but having somebody from the Department of Agriculture that's knowledgeable in equine health, that could be a foreseeable situation. That's the only caveat I would say as an example there.
That would capture cats, dogs, anything else as well, though, if you did
Arguably
that
so.
broad. And I don't know that Commissioner Harper wants to be, the dog catcher as well, prosecuting people for not feeding their dog or their cat.
Senator Hatchett?
Yeah, so just a little bit of discussion on this amendment. I think what Senator from Athens is trying to do. I think it may not be needed because of line 16, where it just says, within the jurisdiction of the commissioner or the department as provided by this title and titles 4, 10, 16. So I think in reference to any of those titles, it's only specifically those that are, those powers that are within the jurisdiction of the commissioner or the department.
Okay.
So it just says the commissioner shall be vested with police powers to enforce those laws governing matters within the jurisdiction of the commissioner or the department as provided by this title or those other titles. So I don't.
That's the problem, you're adding those other titles. Which includes this. In addition to those others, you're now adding Title 16.
But I think
there's an and there, the second word in line 17 is that what expands those traditional powers. We've already done it to 4 other titles, 4, 10, 26, and 43, which are more agriculture related, and this now adds more to that. The and's what gets you.
Well, I guess, is it not limited by what you finish that line out, lines 18 through 20?
Now, there's another and on 18. That's in addition to. You're talking about the bioterrorism and et cetera. So that's yet another grant of their authorities.
Senator Setzler.
Thank you, Mr. Chairman. I'd love to hear from the Agriculture Commissioner. It sounds like his interest is to do this only to the extent that there's an agricultural nexus. I mean, if we can agree on the policy, sometimes we can debate the wording, and I think it's important that we get the wording right here in this committee. I guess the question is it the author's objective, the objective of the department to make sure anything in Title VI is specifically limited to an agricultural nexus? Is that
Mr. Harper, you want to come back up?
So, yeah, I mean, that's the purpose of our law enforcement division, is to investigate those cases specifically related to the department and the jurisdiction of the department. So livestock is the jurisdiction of the department, which is cattle theft. We oversee companion animals, which are dogs and cats. So animal abuse, dog fighting. All of those cases would have an agricultural nexus because those are the jurisdiction of the Department of Agriculture. Those are the cases, and we are working those cases currently. Actually, we're working some of those in conjunction with PAC. And I think, for clarity, I don't know that I said this, the Prosecuting Attorney's Council helped us with this. I asked them. We worked on this together. They are supportive of what we're working to do because they understand the clarity in the law is needed. I would argue that there is a provision in current law that says the department shall have the authority to arrest any person found to be in a violation of any criminal law when the enforcement of such law is provided for. So I would argue that's the reason I said I think under current law we probably already have the authority, but we need the clarity in law to ensure that we do have the authority. That was the issue we were dealing with, working with PAC to ensure that when we do bring those animal abuse cases, working with the statewide prosecutor, and we bring those to court, that the law is clear, that our law enforcement officers had the authority to issue those warrants and take out those arrests. This has been a partnership between local law enforcement, our federal partners, so we're not looking to get outside of our lane. Our lane, I think, is clear, and I agree with Senator Hatchett that it does require that agricultural nexus for us to execute that authority under the law.
I only asked the question. I just want members of the committee to be clear on what we're doing. There may be agreement or disagreement. If and I'm not asking leading questions. I'm just saying if it's your goal that you only have jurisdiction over things that have a clear agricultural nexus, then I think whatever we write needs to accomplish that. If it's your goal to say, hey, that's usually what we do, that's where we invest our resources, but we already have the ability to go outside of that, and we should not be concerned if this further effectuates us enforcing any law, and you think your folks should be able to enforce any law, then let's just say that. But I think we ought to know what we're voting on. I need to read these ands, and Mr. Chairman, I just think the committee ought to read the ands and understand what they're voting on. That's all. And so is it, I mean, do you have the authority to work outside of that which has an agricultural nexus? If you do, or you want to, let us hear that. We can debate how we feel about it. I just want clarity is all I'm looking for.
If I may, to my friend and former subcommittee chair cohort, just for a little context, Title IV, that deals with animals. If you want to look that up, deals with livestock among others. It's interesting. I'll just read a couple of them off. Chapter 3 of Title IV, livestock running at large or straying, prevention and control of disease in livestock, disposal of diseased, disabled, or dead animals. That's just part of Title IV there. Title 10, commerce and trade, which is, these are already under their purview. Chapter 26, food, drugs, and cosmetics, think about the Vidalia onion situation we've got. And also Title 43, professions and businesses, which allowed them to assist with the little meat processing plant situation that we had. So to me, the addition of Title 16 to help effectuate the criminal elements that are committed by those in the state with the agricultural nexus. It's not like they're going to be going in and busting into drug houses here. I would not read that as giving them that authority or being within their jurisdiction.
I think just for clarification and just to break it down, and I, you know, I'm not an English major, but the law says the commissioner shall be vested with police powers to enforce the laws governing matters within the jurisdiction of the commissioner or the department, as provided by this title, as provided by Title IV, as provided by Title 10, as provided by Title 16 now, as provided by 26, sir? No, if this change, as provided by 16. So it would say, if you break it out, the commissioner shall be vested with police powers governing the laws within the jurisdiction of the department under Title 16. So in other words, if it doesn't have a nexus with respect to the Department of Agriculture, we could not enforce that law. Murder would be a perfect example. We could not effectuate arrest for murder because that does not have the nexus to our jurisdiction as an agency. And so I argue that as Senator Hatchett argued, I believe it's clear within the law that it has to have that nexus.
All right, we have a proposed amendment that's been seconded. Does everybody understand the amendment on line 17 and line 24 to replace 16 with code section?
I apologize for wording purposes. Just to make it read correctly, I would strike the 16 on line 17 and 24 and insert following the 43 in both of those lines and code section 16.820. That will make it read more cleanly.
Read it one more time, please.
That is on line 17 and 24, I would strike the 16 and following the 43 on each line, insert and code section 16.820.
Okay. All those in favor of the amendment, please raise your hand. All against? The amendment fails. Any other amendments? Senator Calzert.
I'd like to propose an amendment to give the clarity that Senator Setzler's asking for. I think if on lines 17, following the word pursuant thereto, you add provided that there is an agricultural nexus. And similar language on line 25 following the thereto. That'll make it clear that these enforcements would have to be an agricultural nexus between the crime, which Title 16 is all crimes.
Is there a second for the proposed amendment? Second from Senator Parent. Any discussion on that amendment?
Just add the words provided that there's an agricultural nexus. That's what the commissioner's seeking enforcement of. So it would include all of Title 16, every crime we ever passed, but it would have to have an agricultural nexus.
The only
Ben, do you
thing I
know
would-
where, are you good with the language, Ben?
Provided that there is an agricultural nexus added on line 17 and 25 after there too.
Right.
Okay.
I'm okay with that.
Senator Hatchett?
My question is with Title 4 and 10, 26, and 43 that's already in that code. I mean, I'm assuming everything in that code has an agricultural nexus, or are there any things in those, excuse me, I say code, or is there anything in those titles that the commissioner or the department has jurisdiction over now that doesn't necessarily have an agricultural nexus? I mean,
Domestic pets, is that agricultural?
well, I mean,
It's probably not defined by
wild
law.
animals, is that agricultural? I mean, I don't know if,
Is the
This-
term agricultural nexus a defined term? I'm assuming it's not.
I am also assuming it is not, if you give me just 1 second.
Yep, Mr.
I just don't want to limit what he has jurisdiction of now, excuse me.
Jurisdiction of something that the Department of Agriculture
Becomes a circular.
Senator Setzler?
I was just asking, and to his point is, I mean, it seems like domestic animals and other things, is that an agricultural nexus? It may be, I think your charge is a little bit broader than agricultural because of that, right?
Mr. Chairman, if I may. So Senator Seltzer, to your point, that's why I wanted to get some clarification from my friends in the back, just to make sure. I agree with you. I mean, what does agricultural mean? I think in agreement with Senator Hatchett, that the law already accomplishes what Senator Cowsert is trying to accomplish. I believe that the way the law reads, it has to be within the jurisdiction of the commissioner, within the jurisdiction of the department. So there are a number of criminal laws that we could never effectuate because those laws do not fall within the jurisdiction of our authority to investigate. So when you use a term, and I know I used the term agricultural nexus because I was referring to the department. Maybe I should have used a more broader term of the jurisdiction of the agency. What the jurisdiction of the agency is: agriculture, livestock, plants, animals, welfare of our agricultural goods, food safety, food security, bioterrorism, terroristic threats. The law specifically says that we're supposed to investigate those issues related to terroristic threats to agriculture. And so if we're investigating those crimes without proper authority to effectuate and prosecute those cases and those arrests, how are we supposed to effectuate and prosecute terroristic threats to agriculture if our law enforcement officers don't clearly have the authority under the law?
All right. Real quick, Senator Cowsert.
Well, you do clearly have that under the law because it's here on lines 19 through 21. You don't, and that's not being changed by this bill. So if it makes it clear to put my limiting language after Title 16, so it doesn't capture 4, 10, 26, and 42, which I don't think it interferes with those because those do have agricultural nexuses already. And we could move that language to following the Title 16.
Senator Hatchett.
Yeah, I think just to the author, with Title 10 you were talking about earlier that deals with consumer trade, in that is the regulation of gas pumps. And then Title 10, it gives the Department and the Commissioner of Agriculture jurisdiction to regulate gas pumps, but it doesn't give them the jurisdiction, which I was looking, opioid litigation might also be in there.
That's
But
correct.
it doesn't give you the
No, sir.
authority to do that.
We
So
don't have that authority
each
because the law
title-
doesn't give us that authority.
in each title, your jurisdiction is pretty cleared out, and what we're saying
That's
is
correct.
in these titles, you'll have police power if you have the jurisdiction.
That's correct. And under current law, there are a lot of things under Title 10, under Title 43, and Title 26 that we currently have no jurisdiction over as an agency because it doesn't fall within the jurisdiction or under the enforcement authority of the commissioner or the department. So our enforcement officers can't effectuate any provisions under those specific provisions of 10, 16, or of 10, 26, or 43 under current law because that falls outside of the jurisdiction of the department. Adding Title 16 would line up with the way we effectuate current law with those particular provisions. It has to have jurisdiction to the agency, to the department. And so, again, like I said earlier, this is clarity in the law, an argument could be made that we already have the authority with the way the law reads, but because we want to make sure that if we effectuate those cases, that they don't get thrown out in a court of law. And I think it's important that we do that for the protection of our consumers, our farmers, and our agricultural industry across the state.
All right, we've taught this to death. Let's go to the vote on this second amendment that's been offered by Senator Calzert. There's been seconded. All those in favor of the amendment, please raise your hand. We're at 2. All opposed. The amendment fails. We're back to the underlying motion to pass by committee substitute. All those in favor of the motion, please raise your hand. 6 opposed. 2, the motion carries. Who's going to carry the bill in the Senate?
Chairman Russ Goodman.
All right. Thank you. Thank you, Commissioner.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman, members of the committee.
All right, back on the agenda, House Bill 993, Chairman Powell. We are working off of LC 481200S. And this is as passed in the House. Welcome, Chairman Powell. The floor is yours.
Thank you, Mr. Chairman, and ladies and gentlemen of the committee. I bring to you this bill today, 993, House Bill 993. And I want to preface a few things. One is I'd like to give thanks to a lot of the folks who's helped work on this. This bill came to us through an event that happened in my district. I don't mention names, either the perpetrator or the victim, because criminal charges are still standing. And I certainly don't want to do anything to give defense lawyers any reason to file motions to dismiss for prejudicial information. But I will tell you that this bill came to y'all because of a young lady, a young girl, who at the tender age of 11 years old at a YMCA, and coaches who were coaching this child. And I'd never heard the term grooming. I'd never heard that term until this event happened. This young lady was captivated, as best I can tell from the stories that I hear. And at the age of 16, a romantic encounter ensued. Short-lived, but when he walked and went to another supposed victim, then this young lady, basically what happened, she had a nervous condition, a mental condition, and took her life. It was a couple of years. Now, I'll be honest with you, ladies and gentlemen, in my 34 years in the legislature, I didn't know that we had anything, that we'd left any rock unturned when it came to sexual molestation and aggressive behavior and such as that. Now, when I say I want to give thanks to several people. I want to give thanks to Judge Gunner over in the House, the former chairman that just left here, Smith, and a lot of folks, because we've been working on this for about 3 years now. And quite frankly, when I say that I didn't know we had a stone unturned, we didn't. Because there's nothing in the statutes about this type of behavior from these predators. And what you see in front of you is a simple bill. And when I say that we have been through several bills and several renditions, and none of them seem to fit. The first bills that we had came out with would have been add-on penalties. But that still just didn't quite make it to me because of the behavior of these type of individuals and predators. And then, thankfully, the Prosecuting Attorney's Council worked with me. Ms. Brannis here that's with me today, because we still have another amendment because we're still trying to hem this up. One is so that we're not passing something that might be appealed at some higher level. But we need to add a couple of more issues that we had left out. So it's a constant work in progress, ladies and gentlemen of the House. What this bill does, this creates a criminal penalty for those who would groom a minor through a pattern of activity and by the use of electronic means to persuade, induce, entice, coerce that minor to engage in a sexual offense or human trafficking or other offenses within Chapter 6, Title 16. The person who commits this crime would be subject to a felony. It only applies to people over the age of 18 who is not within 4 years age of the alleged victim. So we did reach out to try to take into account the Romeo and Juliet clause, and that's what you have before you today. I've had Ms. Brownus with us because we need to add a couple of things as far as amendments to this bill.
Good afternoon. My name is Lelaine Briones. I'm with the Prosecuting Attorneys Council. One of the things we need to tighten up is to make sure that there is a definition of grooming in this bill. The original bill, which was LC 481019, had that definition. It inadvertently was taken out of the substitute, which is LC 481200S. So we would recommend that after line 17, where sexual servitude is defined, that the definition of grooming be added. And it, again, is the same definition as in the original version. And that definition is as follows. Grooming means actions or behaviors used by an adult to establish an emotional connection with a minor, to gain such minor's trust for the eventual objective of sexual abuse, manipulation, or exploitation. Such actions and behaviors may include, but are not limited to, contact made online, in person, or by other means of communication. We would also ask that at line 19, after the word pattern, that the word grooming be placed, pattern of grooming activity. So again, it is clear the behavior that we are criminalizing so that innocent behavior is not criminalized. And the last amendment would appear at line 22, prior to the phrase "to engage," to make it consistent with enticing a child for indecent purposes at Code Section 16-6-5, to add the language "or coerce a minor with the purpose to engage," to make it consistent with enticing a child for indecent purposes. What this bill does is, a good example is this summer I prosecuted a defendant in Muskogee County. He was charged with sexual contact with a minor and also child molestation. He was a coach at a high school. He bought a cell phone for a 15-year-old student. He then began to contact her, making what other than I would call dates with her. They would meet in the band room. He would buy her gifts. They wrote love letters. That's grooming. That's what this bill would punish. It is a standalone. So had I had this piece of legislation, what I would have charged him with is grooming, as well as the child molestation, as well as the contact with a child who was being supervised by that teacher. This solely prohibits the act of grooming. It is a standalone from the actual child molestation, very similar to enticing a child for indecent purposes. You don't have to actually prove that the child molestation occurred. You just have to show that there was grooming. And you will find in a lot of child molestation cases, this is how they gain access to their victims.
All right, any questions? There are people signed up to speak on the bill. Any questions for the author on the bill? All right, let's go through everyone that wants to speak and let y'all come back up. We'll start with Thomas Weaver. And Mr. Weaver, you also, I think, gave us a letter that we have in our file.
Mr. Chairman, thank you first for alluding to the letter that I sent to you based on the invitation that was received from Ms. Holcomb that I sent to Christopher Dent based on the instructions. Also, please know, and I want to share this publicly, I have a tremendous amount of respect for Representative Powell. This is not anything against his bill personally. However, we talk about consistency in the law. I would hope that every member of the committee had the opportunity to review my letter if you chose to read it. Not that you had to, but I hope that you did. I have a few concerns with this measure that need to be brought to light. I understand what Representative Powell is trying to get to, but there's a few legal issues. First and foremost, I was actually in the room earlier in the session when my district attorney, our interim district attorney, I should say, Susan Treadaway, presented the incest bill. Commentary was made then, as it's been made in many, many meetings past, that the age of consent in Georgia is 16. Here, minor is defined as a person under 18, but on line 23 of the measure, it references crimes that are encapsulated under Chapter 6 of the title, where those crimes, the age of 16 is enumerated, so you'd have a conflict of interest there as far as, or you have a conflict in the statute, it's probably a better way of wording it. Moreover, if you look at the chapter and the article and the part that this offense that's proposed to be created would be placed under, based on Legislative Council's referral as drafted, and you look at the provisions of the existing code sections within that part, within that article, within that chapter, what constitutes a child or a minor for purposes of public policy here is all over the board. You have under 18, unmarried under 18, under 16, under 14, and now you want to bump back up to under 18. It's confusing. It's inconsistent public policy, and I would submit to each member of the committee that maybe the public would be, and I don't make public policy here, y'all do, but maybe the public would be better served if the policy that was, if the legislature were to choose to move forward with this measure, maybe the public and your constituents would be better served if 16 was the age here to make it consistent with existing law that's already been referred to the committee by professional witnesses and also many others, not just here today for my testimony, but over the years. If you look at the bill more specifically, it says even in person, acts in person, and then it defines a minor under the bill as someone under 18. So it would be more of a crime, and forgive me for not having the social graces and manners of being able to say this more eloquently in such polite company as all the esteemed persons who are in the room. But it would purport here to make it a crime for someone to groom a minor in person who is 16 or 17, but not yet 18, as opposed to just not even interacting with the computer or with the social media or all these different apps that they use, and just move straight to the sexual part of it. Because if you skipped all of that and you just move straight to the sexual part, all of a sudden the age of consent is 16 again. It's awkward, it's peculiar, it's really weird. It would be like saying, I know it's not conducive to the bill, but it would be like the legislature saying you have to be 21 to buy liquor but 30 to buy a beer at the bar. It's just really weird that you're making this age as drafted all over the board, and I would just ask if it should be the will of the committee, and you have to forgive my nervousness because this is really not something that anyone would talk about directly, and it's kind of just weird for me to even share it, but I think 16, just based on the laws that exist all over the official code of Georgia annotated, just make it consistent public policy is all I'm asking if this is something that you want to move forward to. But again, I do want to point out one other thing. As the district attorney alluded to, 16-6-5.1 is a crime that's been worked on repeatedly through the years. That's sexual assault by a person with disciplinary and or supervisory authority against the person in custody. So if someone is a high school whatever and they are engaging in sexually immoral acts or sexually immoral contact or behaviors, sexual battery with any student, the age of the student's immaterial under the statute. It's automatic. Ditto for people who are in foster care with foster parents. Ditto for people who are in correctional custody by correctional actors, law enforcement against arrestees. The law, the policy already exists. To the extent that you're going to expand it to include alleged defendants whom are outside of these custodial arrangements, the existing law says 16, and here you purport 18, and I just think it can cause a huge mess more than it would solve if that's not clarified.
Thank you, Mr. Weaver. Any questions for Mr. Weaver? Senator Setzler.
So, and again, Mr. Chairman, I can direct this to, well, I'll direct this to another person. We're good.
All right, thank you. Next, we have Ms. Susan Cobb. Good evening. You want to set it on the bench in the front where that, there you go.
Thank you for having me here today. I first want to thank God, and I just want to give him the glory that this bill has came this far. I want to give thanks for some people who are here today that has made it possible, who has listened to me and my family, and that would be Senator Bo Hatchett and Representative Alan Powell. My name is Susan Cobb. I am a mother, wife. I'm a registered nurse with a master's degree. My husband, Wayne, and my son, Austin, are here with me today. Our child was groomed, and it started at age 11 by her gymnastics coach. And we did not know until she was 14. The reason I'm here is because we want the laws in Georgia to be changed. We want the laws to become tougher. We want Georgia to stand as the state with the toughest laws for those who molest and groom sexually our children. We want to be the state that sets a standard for every state to follow. I want to tell you about our daughter, and I want to tell you about her story of grooming. It's still a case, so I'll leave names out and locations, but I want you to understand what it's like as a parent to live from when your child is 11 until she's 20, going through grooming. Our daughter was beautiful. She had a beautiful soul. She loved animals. She loved to ski. She loved to snow ski. She loved gymnastics. She loved the beach. She loved Jesus. And she loved her 2 dogs that were German Shepherds, Abby and Ava. She loved her friends and her family. But the first thing that the groomer does is he takes her away from her friends. And once he's successful at taking her away from her friends, he takes her away from her family. Unfortunately, I taught stranger danger. I did not know about the term grooming. Apparently, grooming has been discussed by psychiatrists since the year 2000, excuse me. Jennifer was groomed not just for sex, but she was groomed for marriage. The intent was to gain her trust, manipulate her, keep her looking pure, and one day marry her. We first found out when she was 14. An incident occurred at our home where he came from the Army to visit. An inappropriate incident. An incident that our adult 18-year-old son witnessed. An incident that you don't want to, as a parent, hear about. We send our sons and daughters to fight foreign wars for our country, to never return. Yet our son's statement of what he witnessed was never investigated nor used for an investigation. Because she was already groomed and molested and brainwashed not to tell anyone from age 11 to 14, which we did not know about until later, she was afraid to tell the truth because she was told, if you tell the truth, if you tell anyone, your dad will kill me and he will go to prison and you will lose us both. So when we reported that incident and she was asked about it, she said nothing happened and it was dropped. There was no investigation. We were told by the investigator, ma'am, if you think I'm going to go knock on every mama's door who's at gymnastics, well, you're wrong. And furthermore, let me tell you, ma'am, if you leave this office and you talk about this man, you can be charged with defamation of character. And I, being a registered nurse, knew that I am a mandate reporter. And I had a right not to only protect my daughter, but all the children within our community. Jennifer started losing her hair at age 12. We thought it was autoimmune disorder. We picked hair up off the floor, out of the dryer. We didn't know why. We took her to every dermatologist. We thought it was autoimmune. We did not find out until later that she had pulled every single strand of her beautiful blonde hair out. And I know in my heart that the Jesus within her fought against the evilness of grooming. Grooming is evil because you have an adult person who is trying to manipulate, control, brainwash a young child for their own sexual gratification. We made several reports to the police from the time we found it out at age 14 until 17, and even filed a missing report person. Our husband even called them again meeting. We had thought that, surely, he would stop, and they had told him to stop. But they didn't. There was nothing to deter him. We were told he was a coach. He can touch her. Nothing wrong with him touching her. He can call after midnight. There's nothing wrong with calling after midnight. He can meet her at places that she shouldn't have been at. There's nothing wrong with meeting people. I would say there's something wrong when the child is 11 years old and the man is 17 years older than that child. There's something wrong with that. This is not a Republican or a Democratic issue. This is an issue we have in our country, and this should be a bipartisan issue. This continues on, and by the time she has lost all of her friends and spends her teenage years with no friends because he has complete control over, then he turns her against us, and she moves out at 18 for him to propose to her at 19. And then we prayed a different prayer. God, open her eyes. Let her see the truth. And he did. Unfortunately, she started seeing the tactic he used on her, on other children. And Jennifer, being Jennifer, there's two things on this earth she would die for, and that would be another child or an animal. And that's why she had the courage to come forth. Most victims do not have the courage to come forth. They're not ready. They're embarrassed. They're threatened. They're scared. They may never come forth. I've had people contact me in their 60s and tell me they've never told before, but they were a victim. But Jennifer felt that she had that child to protect and the other children she's seen. Then in the year of 2020, she started going back to therapy and decided she wanted to come forth and tell. And because it had been botched for so long, Sheriff's Office didn't want to touch it. It was turned over to the GBI. And 18 hours approximately, I would say, after she spoke to the FBI, he was arrested. And he was charged with child molestation, statutory rape, enticing a child, indecent purposes, criminal attempt of sexual exploitation, criminal child pornography. At 11 years old through 14 years old was the photo taking and the messages, the secret apps, the things we didn't know about, the getting control. So the using the computers and secret apps was the way to communicate, and because they were secret apps we didn't know, and pictures were shared. It was 14 when she lost her innocence in the field behind our home. He was a walk away through the woods. Not only was he her coach, he was a walk away through the woods. After he was arrested, it went before a bond hearing, and that was in 2021. And she was asked, why did she wait so long to tell? Was she jealous of those children? And then we had two preachers to come forth that were going to marry them who did not see any reason to contact the family to ask if we thought it was okay for a man 17 years older than our daughter at that time to marry as character witnesses. And in a roundabout way, they were asked if he were charged with sexual molestation of a 12-year-old, would it change their opinion? No. Surely they must have heard the wrong question, and they were asked again. No. And the second came forward, and he danced around the question, and he said that he would love, respect, regardless.
Ms. Cobb, I'll let you wrap up in the next 2 minutes if you can. Make sure we keep a quorum so we can move the bill.
I will.
Thank you.
So I just want to say that that day she said that she was afraid if he got house arrest that she would be prevented from testifying. 6 days later, she was pronounced dead by hanging. So I say to you, this bill is important because it will save lives. It will save children's lives in the state of Georgia. And also it will send a message to those predators who seek out our children that if you do this, if you groom, if you brainwash, if you buy them presents secretly, if you touch them inappropriately, if you're their coach, their teacher, their neighbor, their uncle, and you're inappropriate with them, and you sexually groom them, then you will be held accountable, and there is a law in the state of Georgia you will be charged with, and it will be House Bill 933, where you will be charged with a felony. And I just pray that today you will all see and be united to vote yes on this bill.
Thank you, Ms. Cobb, and thank you for being willing to share your story, your daughter's story with us to make this big of a difference. Appreciate you being willing to do this. Any questions from the committee? You do have a question, Senator Hatchett.
I just want to say thank you for all that you've done, for the many years you've been working on this, and for reaching out to me and reaching out to Representative Powell, and just you should be very proud. And I know that you're doing this for the legacy of your daughter and to protect people moving forward. And just want to thank you.
Thank you. Thank you for everything you've done too.
All right, thank you.
Thank you.
We have one other person signed up to speak, Taylor Hawkins with Frontline Policy.
Thank you, Mr. Chairman. I'll be brief. Taylor Hawkins with Frontline Policy Council. I want to start by, of course, recognizing the incredible courage of the previous testimony. For time's sake, I will not share personal testimony as well, but there is someone in my immediate circle who suffered a very similar, a circumstance that would be captured under this bill. I won't say exactly similar to the previous testimony, but and it opened my eyes to the incredibly successful psychologically manipulative tactics that those who would be captured under this bill are able to use in order to gain the trust and manipulate the trust of some of the most vulnerable in our society. Those young people often don't understand they're being groomed. They're targeted based on emotional neediness and isolation, lower self-confidence. And I just think this measure by Chairman Powell will be an incredible measure to close a loophole that has long since needed to be closed, and would provide justice for those who are victims of grooming, regardless of whether they are victims of additional child molestation. So in the interest of protecting the human dignity of those victims, our organization would like to offer our full endorsement of House Bill 993 and urge this committee to pass this piece of legislation.
All right. Thank you, Mr. Hawkins.
Thank you.
That's everyone that's signed up to speak on the bill. What's the pleasure of the committee? Motion to pass by Senator Hatchett. We have a second by Senator Parent. There were 3 proposed amendments offered from the author, and one of them was really a part of another bill that was a little bit longer. Let me ask first, Ben, did you get all 3 proposed amendments?
I did not catch the third.
I believe the third was on line 22, after the word minor, be with the purpose to engage. Is that correct?
Yes, Chairman.
Okay. So
Just with the purpose to engage.
right. So, or coerce a minor with the purpose to engage was what was suggested to us.
Chairman, I do have some concerns about including that definition from the First Amendment, if this is the proper time to.
Please go ahead and address that.
I believe that most of the elements of the definition of grooming from that earlier bill have been incorporated into paragraph B, starting on line 18, to include a definition of the word grooming that has a lot of duplicative elements into the definition of the crime, I believe could create the possibility of confusing the elements of that crime. If there were some specific elements of that definition that could, be worked into paragraph B, I think that would be more specific and grounded for the purposes of establishing the elements of the crime.
Does the author want to come back up to? I'm sorry, I didn't catch your last name. What did I do with the sheet? What did I do with it?
Chairman, I'm sorry. My last name is Briones.
Briones. Oh, I got you here. Okay, Ms. Briones, do you want to address that?
Sure. So in paragraph B at line 18, A person over the age of 18 and no less than 48 months older than the alleged victim commits the offense of grooming of a minor when such person through a pattern of activity. I believe that's where he is suggesting that we not place the word grooming. It is important, I think, to put a pattern of grooming activity in there.
I think he was addressing guiding the definition of grooming again.
Okay.
Right?
That's correct.
He was
Yeah.
we didn't get to the second part.
Okay.
I guess you probably wouldn't use the word grooming if it's not defined.
Right, and that's why you have to have a definition of grooming, because if you don't, you're going to encompass behavior that may not be criminal. You know, a teacher that gives a child school supplies, or just things that are innocuous. Grooming has to be a pattern of behavior in which the text messages or giving the phone, whatever that conduct is, the mens rea is they're doing it for the purpose of obtaining or manipulation or exploitation. That's why they are perpetration. That's why they are performing these acts, and that's why it's very important to have a definition of grooming.
Look, on lines 22 and 23, the definition that's used here when it spells out the act of grooming, it does go on to reference the sexual offense, trafficking of persons for sexual servitude, any offense provided in Chapter 6 of this title. Does that not limit the type of activity that would qualify for grooming?
No. So to engage in a sexual offense, trafficking of persons, that really goes to the mens rea. That what we have to prove is that this person committed these pattern of activity with the purpose either to engage in a sexual offense with a child or to traffic a person. So these sexual offenses are not the definition of grooming. What we have to prove is that this defendant had the mens rea, the criminal intent to do all these acts with the purpose of engaging in that behavior.
So your argument would be defining grooming, then when you add the word grooming before activity, that would limit the type of activity.
Correct.
Back to the definition.
Correct.
We have a couple members of the committee. One, Senator Setzler.
Thank you, Mr. Chairman. Yeah, I think it's, I looked at line 21 and 22, to persuade, induce, entice, or coerce. You still have to, that would still have to be proven that if there were a pattern of activity that didn't use the definition of grooming, I don't know why you would want to, I don't know why grooming is necessary either when you've got, at the end of the day, it seems that you've got, you're going to have to prove up line 21 through 22. So I just say that parenthetically. My question to you is, and again, to those who are watching today, this is not easy for these members of this committee to wrestle with these issues, because what we heard about is horrific behavior that clearly meets the definition. My question is the line, drawing the line at minor means under the age of 18 as opposed to under the age of 16. To Ms. Briones, isn't it true that current Georgia law allows a 17-year-old to willingly have sex with a 30-year-old or a 35-year-old, and that's completely not a crime, correct?
That's correct. The reason why we use the definition for minor is that minor also encompasses offenses like sexual exploitation. So defendants will groom children for the purpose of sexual exploitation as well. So we wanted to encompass those victims in the sexual exploitation statute, as well as the human trafficking statute, which doesn't deal only specifically with children. So what we would have to prove is that this child or the person was a minor, and and this person groomed this individual for the purpose of trafficking. So in that instance, the definition for minor would fit with what the mens rea of that particular defendant wanted to accomplish, as well as sexual exploitation, which uses the definition minor.
So and again, Mr. Chairman, I would say then it seems like you need to kind of split this, because if your interest is making sure that 16-and-a-half-year-olds and 17-year-olds who are being groomed for sexual servitude, you can get people for grooming. I understand your public policy interest, and that makes perfect sense to me. I'm just saying it doesn't make sense. I don't see how we could act on something that said if you're grooming a 16 and a half or 17-year-old who could have sex today with a 25-year-old or 26-year-old, completely legally have sex today, how you could have a grooming to have sex be a crime. I mean, it doesn't seem to follow you could ever do that. If it's legal today for a 25-year-old to have sex with a 17-year-old, then how can it be illegal for them to groom a 17-year-old to have sex?
Well, I will say this. I think the purpose of the statute and defining minor is the victim has to be obviously a child or a minor. So it wouldn't be contradictory to what you're describing if the offense is sexual exploitation, because sexual exploitation punishes the sexual exploitation of a minor. A minor cannot agree to participate in sexual exploitation.
Correct.
So that's why we've broadened it. For
sexual exploitation or servitude, I completely agree with you on all of those things. But taking it out of that context, for sexual activity, what would otherwise be consensual sexual activity. I mean, Mr. Weaver raised the question. It's something I think we've got to divide here as a committee is if, and this is not being insensitive to the issue, I'm just trying to make sure we're good at getting law right. If someone is enticing not for servitude, not for exploitation, but is enticing for sex, it can't, this legislature cannot enact a statute that says it is a felony to entice somebody to have sex when it's completely legal to have sex. So this gets to the issue of the age of consent. We have an age of consent of 16, and all that Mr. Weaver asked was, as long as we're going to maintain an age of consent of 16, you can't make it a felony to groom someone for a subsequent sexual act when the act itself is legal. It could be effectuated today and be completely legal. So to me, we've got, Mr. Chairman, to split this out and say, hey, it can absolutely be a felony to entice a minor for sexual servitude, sexual exploitation at age 16 and 17, because that's never okay, even for adults. But for minors, I think we've got to draw that line. If it's otherwise lawful activity that they're being enticed to, it's absolutely a felony if they're 15 years and 11 months. But once they hit 16, it becomes legal at that point. And unless we're going to change their entire framework of age of consent in Georgia, we have to split this out, it would seem.
It seems like to me, unless the committee has strong feelings otherwise, based on the change we need to make anyway, we need a consensus as to whether we need that definition. And so I think my preference would be to do a substitute for the bill next week to get a bill out that we know has the right language versus us doing this on the fly. Because we have a disagreement between what you're saying, what Legislative Council's saying, and then we're also hearing from other people about other potential concerns. So I think the bill needs to move, but we need to make sure we get the language right. Other questions from the committee? Senator Jones?
Mr. Chairman, I just say that for consistency across the law is all I'm trying to say. We need to be clear. If this General Assembly wants to change the age of consent to 18, that's a policy discussion we have. But as it stands at 16, we just need to be consistent with that.
Senator Jones.
Thank you, Mr. Chair. Number 5. Of course, we are going to be moving this legislation, as Mr. Chairman said, we do some work on it, but I do want to say that what we're doing is we're placing this within the sexual exploitation statute, and this language actually follows the sexual exploitation statute, where the minor is defined as under 18. And what the prosecutor is saying is that we're placing this under that particular statute. And so we're not really deviating it at all. We're calling this sexual exploitation, and we're creating within that statute. So it's our purview not to call this sexual exploitation, but not only the language of under 18, just even the language as far as like inducing and things of that nature. It's all in the sexual exploitation statute. So we've already done this to some extent.
Senator Hatchett?
Yeah, and I want to my friend, Senator Setzler, this says to coerce a minor to engage in a sexual offense. The minor's under the age of 18. So in your hypothetical, if you can legally do it, that's not a sexual offense. But when you're trying to coerce them into a sexual offense, which is sexual exploitation, sex trafficking, those things, that's where the difference is. So I think your concern is addressed with that language, although you do bring up a good point.
If
Senator
that's the case,
Simpson.
Mr. Chairman, I appreciate the minority whip's perspective. If this is limited to this code section or this chapter, and it's as the senator alluded to, it probably does address itself. I was of a mind that you're grooming a child for sex, not sexual servitude or sexual offense. If it is narrow, then the problem solves itself. I just wanted to raise that for consistency. So,
I'd agree with Senator Hatchett. It says in a sexual offense, and then it talks about trafficking or other offenses provided in Chapter 6. So I do think it has to be a crime that you're grooming someone to commit. But we're left with the issue of the definition of grooming. That's what gives me concerns as to whether we need to have that definition spelled out or not. Senator Rhett.
No, I agree with you. I don't think we should put much emphasis on the intention, but the actual act itself. Just like myself, Christmas, Easter, before school, I walk up and down the street and give gifts to book bags and stuff to kids. One kid thought I was the chocolate Easter bunny, But I'm just being nice, my church and activities, but I just want to add that. But we're going to get there. We'll work with you and get there. We just need to tighten up a few things.
Let's do this. We'll put this bill back on. We're going to hopefully have a hearing you'll hear about on Tuesday morning on our committee day to give us an extra day next week. Otherwise, we're hearing Monday and Thursday next week at our usual time. Let's work on a substitute that will address the question, if y'all can get with Legislative Council on the definition of grooming, whether or not these be added or not. And we can come back with a substitute next week and just move the substitute out for a motion to pass. Does that work?
Thank you.
All right.
Thank you so much.
Thank you. All right, we're going to get back on the agenda. I know some people have to go places, so as long as we keep a quorum, we will keep rolling. House Bill 1203. Representative Kelly. We are working off of LC 481190, which is the version you passed in the House. Is that right?
That is correct, Mr. Chairman.
All right. The floor is yours.
Well, thank you, Mr. Chairman, members of the committee. I know we've been working for a few hours here, and so try to be as brief as possible as I can with my comments. What House Bill 1203 looks to do is address a situation that really developed as a result of backlog created during COVID, when a lot of evictions were stayed and told during the COVID process. Once COVID was over, we've had a huge backup in our system in terms of evictions, and we haven't. A lot of agencies aren't equipped to handle the backup. We heard in Fulton County, I believe it's about 3,200 evictions are waiting to be processed in terms of being set out by the constable. And so what this does simply is, if one of these dispossessories is not able to be executed within 14 days by what I call the original officer, it provides an opportunity for the landlord at their own expense to go out and hire an off-duty sheriff, constable, or marshal from a list provided to execute that for them.
When someone files a dispossessory, don't they pay a fee that goes to the sheriff's office to complete the service? Is there a service fee paid?
They do pay a fee for that.
Is there any concern that that fee remains with a sheriff's office, even though they're not the ones that are actually going to complete the service?
I would say that is something that I understand a concern about. I would say that a lot of this backup hasn't been caused because of them not necessarily wanting to do their job. It's just we're in a situation created with backup from COVID. I would say that if we could just get them some extra resources, I think we could hopefully get this worked back out over the next, couple years. And I would say that if that doesn't, and I also think that there will be, knowing that there's someone else who may get involved in this process, if those original officers aren't doing their job, I would like us to see how this system works and maybe revisit that next year.
And I agree. I think it's a good bill. My long-term concern is if we're going to create a separate path where someone, the resources can pay to have somebody serve, but everyone else is in this other path. I just want to make sure that we are continuing to make sure that sheriff's officers are able to do their job and still move these. And if not, we may have to revisit this down the road. So I agree with you. Any questions from the committee? You have two people signed up to speak on the bill. Mr. Jim Borders.
And Mr. Chairman, I would say just one other thing. I think that there was some conversation about after it left the House as potential improvement for y'all with the measure. We talked about possibly having this effective upon the governor's signature versus the standard July 1st. So I would appreciate if someone on the committee wanted to offer that as an amendment.
Okay. Thank you for reminding me of that.
Mr. Chairman.
Mr. Borders. And then Hayden Stanley as well be next.
They make
Good
it come
evening.
up together if you want to, Mr. Chairman.
Do you want to come on up, Hayden, as well?
We were just going to, if necessary, testify.
Okay.
We're supportive of the bill. We appreciate Representative Kelly bringing it.
Thank you. Mr. Borders.
Yes, thank you for having me and allowing me to testify today. And I'll keep it brief because I know the hour's late. But I'm an apartment owner here in Atlanta and around the state. And this bill is very important. I was at a apartment conference 2 weeks ago, and in every meeting there were two questions asked of me because people know that I'm from Atlanta. And they said, well, the topics were, when's the Fed going to cut rates, of course. And then the second topic was what's going on with evictions in Fulton County and DeKalb, and to a certain extent some other counties around. So the fact is the marshals and the sheriffs just never got caught up after COVID, and so we really appreciate your consideration of this bill, and we support it.
All right.
When are they cutting rates?
Don't know the answer to that. Hopefully soon.
No one else is signed up to speak on the bill. What's the pleasure of the committee? Motion to pass from Senator Rett. We have a second. Second for Senator Hodgins. If we want to add that, I lost Ledge Council. The language that would make this effective upon the signature of the governor. Senator Calvert.
I move to amend it to make that effective upon the signature of the governor.
Is there a second? Second for Senator Hodges. All those in favor of the amendment, please raise your hand. It is unanimous. Going back to the underlying motion to pass now as amended. All those in favor, please raise your hand. It is unanimous. Who's carrying the bill?
Senator Hatchett.
Senator Hatchett. All right.
I appreciate the committee's attention this afternoon. Appreciate y'all.
Thank you.
Thank you.
All right, next bill on the agenda, House Bill 1033. Representative Chairman Leverett. We are working off LC 481264S. Welcome back.
Thank you, Mr. Chairman.
The floor is yours.
All right, thank you, ladies and gentlemen. Mr. Chairman, ladies and gentlemen of the committee, I appreciate very much the opportunity to present to you the Utility Worker Protection Act. This is a bill that kind of is the follow-up to the Critical Infrastructure Bill, which this committee passed last year, and which Chairman Calvert very kindly carried for me on the floor of the Senate. So last year we worked on protecting the machinery and equipment, the infrastructure. We provided an enhanced penalty if someone damaged critical infrastructure. So we kind of protected the stuff, the machinery equipment. This year we're protecting the people who work on the stuff. And we're doing that by creating a separate category within 5 criminal statutes: assault, simple battery, which is different from simple battery, and aggravated assault,
Like, I may have just gotten 4. Let's see. Assault, simple assault, battery, simple battery, and aggravated battery. And so we basically provide that if one of those crimes is committed on someone who is a utility worker, and there's a definition of that in the statute, then the penalty is enhanced. So normally for simple battery, simple assault, and battery, if you commit one of those crimes, it is a misdemeanor. Under this bill, if you commit the crime upon a utility worker while they are acting within the course and scope of their employment or performing official duties at the time of the act, then it's a misdemeanor of a high and aggravated nature. So basically, you're going from up to $1,000 and up to a year in jail to up to a year in jail and up to a $5,000 fine. With respect to aggravated assault and aggravated battery, we're changing the penalty there from, I think it's 1 to 20 years to 3 to 20 years. And so that's basically the bill, or the general structure of the bill. And we have, I believe, some witnesses who will testify. This is not just, we're not doing this in anticipation that this kind of thing might happen to utility workers. It's been happening to them, and we do believe it's a problem that should be addressed.
And we have a committee substitute because we add the offense of battery as well. Section 6, was that the new part?
That's correct. Thank you, Mr.
The only thing
Chairman.
that changed.
We had, when we drafted the bill originally, we had left it battery out, thinking it was not as often charged, but then we learned it is a quite often used statute, so we decided to add that back in, and that's why you have the substitute in front of
All right, any questions for the author? All right, we are losing. One more person leaves. We don't have a quorum.
I know, so I'm trying to be fast.
Everyone that signed up is for the bill. If you think the committee might be for it, keep it brief if you want the bill to move tonight. Or you can come back next week. It might be later. Kevin, I can't read your last name, Kevin. Curtin. Oh, that's easy. I saw the semicolon. It threw me off. Sorry, Kevin. Come on up. Like Curtini. And Lee Swan.
Thank you, Mr. Chairman. Kevin Curtin with Georgia EMC, and I'm here to introduce Lee Swan, who's the Chief Investigator for Georgia Transmission Corporation. Lee has an extensive law enforcement background, can give you a lot of details as to why this is happening around the state and the fact that it is a problem. The folks who are utility workers are really critical workers in every regard, and the fact is that these folks are being threatened on a regular basis. And we depend on these folks to let the economy work. And Lee can give you some instances of that, but I'd like to turn it over to Lee.
Well, thank you. Again, my name is Lee, excuse me. My name is Lee Swan. I'm the investigator for Georgia Transmission Corporation. My background is retired DeKalb County Police, 25 years in law enforcement, and 16 years as investigator with Georgia Transmission. We have seen in our industry the problems encountered by our workers, where many times we have persons threaten to use force against them. We've had persons shoot at some of our workers. Equipment has been sabotaged and threats made to sabotage equipment and to really keep our workers from doing the work that keeps the lights on in this building, or keeps air conditioning on in your home, or keeps anything that runs with electricity within this state moving. And therefore, we have a serious problem here that is escalating over the years, that is not de-escalating. And we are very concerned with the safety of not only electrical utility workers, but also utility workers that are in other industries as well. Even the railroads have problems. You would not normally think that a railroad worker would encounter it, but they do. You have problems encountered by sanitation workers or anyone that's involved with the delivery of a critical service to consumers of this state. And again, those of you who supported the bill that Representative Leverett referred to on the critical infrastructure protection, we certainly do appreciate that, and we would appreciate your attention on this bill as well. And any questions I can answer for you, I'm pleased to do so.
All right, thank you. Any questions from the committee? All right, thank you, Kevin. Thank you. Next, Craig Camuso and Dwayne Massengale for the bill. My mother-in-law says she supports it as well.
That's good to hear. She also clarified lobbyists and said I was actually number one, because your wife is actually not registered.
Well, she's not technically a lobbyist. That's right.
That's right. No, thank you, Mr. Chairman, members of the committee. My name is Craig Camuso. I'm with CSX Transportation. Excuse me. I'm here with Dwayne Massengale, who represents the Brotherhood of Locomotive Engineer and Trainmen. Dwayne is also a CSX employee, and we've got to be very quick because he has to be on a train a little bit later this evening. I'm speaking on behalf of the Georgia Railroad Association as well, which has a little under 7,000 employees in the state and over 4,700 miles. We speak in favor of the bill. We do have incidents where we are having our employees being confronted on various issues. I'll just share one brief example. We were cutting bushes on our right-of-way for the safety of our employees, and the person that was cutting the bushes was approached with a gentleman with a shotgun. So I had to get involved in that. And I'm going to actually let Dwayne speak because I know we're short on time, but who has actual personal experience with this.
Thank you, Mr. Chairman, members of the committee. I'm Dwayne Massengale with the Brotherhood of Locomotive Engineers and Trainmen. Been with CSX for almost 25 years now. But thank Chairman Leverett for carrying this bill. We need it as a deterrent to stop some of this attacks. We've had members shot, other members shot at, and it happens in all areas, not just urban areas, but in rural areas as well. We've had members going out to a train in a rural area and in a van with markings all over the van so they knew who was going in, but sometimes you get these irate landowners who, just want to go out and threaten people, but he threatened them with a shotgun for just coming across the edge of his driveway. And so, we don't want to be having to go to work under these conditions. We already make sacrifices being away from our families and all, moving the freight across the nation, and so we just want everybody to be able to go home safe at the end of the day.
That's it. All right, thank you. Any questions from the committee? Thank you.
Thank you.
All right, Mike Tharp, last one up. Close us out.
All right. Thank you, Mr. Chairman. Thank you, members of the committee. I want to thank Chairman Leverett. My name's Mike Tharp with Communication Workers of America. I've been a technician with AT&T for over 25 years. And I just wanted to share a story that happened to me while I was working out in the field. I had pulled into a neighborhood. I actually drove from Woodstock to Powers Ferry. And this actually happened in 2021. And they had pulled up to a house, the customer wasn't home. I went around to the back of the house. My truck was coned and chalked and everything was locked up. I went around to the back of the house, checked it there, and then I started walking to the front down the driveway to my truck. And when I got within probably 15 or 20 feet, I started to hear beating and banging on the side of my truck, and I didn't see a vehicle at that time. And as I passed around the front of the truck, I saw a car and my fiber splicing equipment going out of my door into another car. And I remember myself going, no. And I just saw myself reacting. I just kind of had an out-of-body experience, to be honest with you. And I just reacted, and I saw that strap, and I thought I could grab that strap. And when I did, I actually put my hand on the passenger door, and the driver hit the gas. And the next thing I know, I was being drugged down the road for I'm not sure how far, but a little voice in my head spoke up and said, you better let go, and you better let go right now, or this is going to get real ugly. So I did let go, and I slid to a stop in the middle of an intersection, and I laid there for a minute, and it kind of came back to and just trying to figure out what happened. Turns out when I grabbed the door and the driver hit the gas, the other person there's leg was still outside the car when they took off, so his leg was actually pinned in the door. So that's probably what kept me from getting caught under the back wheels, because the door was open a little bit. And when I let go, he pulled his foot in and actually lost his shoe, so we actually got his shoe. but when I was kind of got my senses back, it just kind of made my blood run cold, because somebody that bold to come after me at 11 o'clock in the morning, probably carrying, didn't care if I lived or died, made me really worried about making it home to my family that day. So I'm just thankful that I'm here today. I hope you have favorable consideration for this bill, and I'm glad to be here. So thank you so much.
Thank you. Any questions for Mr. Tharp? All right, thank you.
Appreciate it.
All right, so everyone has signed up to speak on the bill. What's the pleasure of the committee? Motion to pass, Senator Cowser, second from Senator Setzler. All those in favor of the motion, please raise your hand. It is unanimous. Who's going to carry this one? Senator Cowser. All right. Want to come up into the next one? Chairman Leverett, House Bill 1218. We're hanging on by a prayer.
I'll be fast, Mr. Chairman. This is a bill that we passed last year that requires notice by an executor to the beneficiaries of an estate once the executor is appointed. The reason for that was Floor Leader Wade had a constituent who had someone got appointed executor. None of the beneficiaries were heirs, so they weren't aware of the appointment, and the executor then absconded with all the funds of the estate. So I co-sponsored last year, we put this bill in. The fiduciary section sort of discovered it later and realized there were some things we did logistically that could be improved, some provisions on the notice that could be approved. So they've weighed in and recommended some changes, and we're trying to get those adopted. We basically give the executor a longer period of time, but we make it a duty so that the executor can be removed and fined by the court if they don't comply with the obligation. And we inserted some provisions to clarify the manner of notice, to provide that it could be waived in writing by the beneficiary so they could just acknowledge. And we also included a provision that provided how you would notify a trust. And what if the trustee was also the personal representative? So we think these provisions make the bill a lot more clear operationally and improve it, and also make it more robust as an enforcement tool, and would ask that you approve it.
All right, Mr. King, you helped on this one a little bit.
Yes, Your Honor.
Appreciate your work.
Just here to answer the questions if y'all have them.
I've never been called Your Honor before, Kyle. All right, any questions for Mr. King or the author, Chairman Leverett? All right, what's the pleasure of the committee? Motion do pass by Senator Setzler, second, Senator Watson. All those in favor of the motion, please raise your hand. It is unanimous. We'll pass anything right now this hour. It's the time to present.
I'm so glad, Mr. Chair. I'm so thankful for y'all and your
We'll
life
pass a ham
discretion.
sandwich, just like a grand jury will indict. All right. Is that all you have?
And that's all I have. Senator Hatchett's sponsor.
Senator Hatchett's going to carry it. Thank you. All right.
As always, Mr. Chairman, thank you, and thank you, members of the committee, for sticking in.
Appreciate
I
your
really
work. Thank
appreciate
you. All right. Representative Reeves, you keep them here. They're still here. They don't look too happy right now, but they're voting do pass. You have a really simple bill, I see.
I do, Chairman Strickland. Despite the length of the bill, it is a fairly straightforward bill. I'm joined by Thomas Powell of the State Bar of Georgia's Business Law Committee, the UCC subcommittee. House Bill 1240 is the Georgia UCC update. It is the first comprehensive update of the Georgia UCC since 2001. It is over 100 pages long. However, the Georgia UCC is over 900 pages long. So this bill is very limited and focused on updating for technology that is progressed since 2001. If you think about the way you banked in 2001 versus now, there have been a lot of changes like depositing checks electronically, paying bills electronically, things like that. The Georgia UCC covers private transactions where money is borrowed or lent on business transactions for equipment inventory, numerous things in our economy. So what this update does is it matches Georgia law with our robust and vibrant Georgia economy. It unanimously passed House Judiciary Committee and the House floor. Mr. Powell and I are glad to answer any questions about this bill, but this just brings Georgia UCC law up to 2024 It was the result of 4 years of study at the national level, National Law Institute. Many states have already updated this update or adopted this update, and I respectfully request your favorable consideration of the Georgia UCC update. Thank you.
All right, any questions from the committee for Mr. Reeves or Mr. Powell? Well, not yet. Dr. Watson. Senator Setzler.
Thank you. Substantively change. What's the and was there any opposition to this? I don't know if I know there's.
No, there was not. What we did do on page 1 of the bill, we added some language saying that this bill does not condone or request or encourage enactment of a national digital currency. So that was one question that got raised and reviewed in the financial community. So we added that to the bill. Other than that, there weren't any changes during the process. What it does, did y'all get a printout of a PowerPoint?
We have it in our folders.
Yeah. Some of the key points, you know, the electronic and remote depositing of checks on page 13, are the sale and lease of goods and hybrid transactions where you have services in addition to sale and lease. On page 15, this is sort of a good example of why this bill is so long. It updated the terminology from writing to record. Back in 2001, everything was handwritten. Now you have a lot of electronic records. Back in 2001, it said signed. Now it includes electronic signatures. It's things like that for the most part.
Senator Hatchett.
Yeah, and I'll try to be brief. I'm wondering, does this have to do with, in any way, shape, or form, like the cryptocurrency? Because I've had people in my district that get, I guess, cryptocurrency stolen from them, and I don't understand exactly how it works. And there's banks are starting to use it to transfer. Does that capture this at all?
Yes and no. It doesn't move things in that direction or condone it or encourage it, but for people who are out there borrowing or lending money or paying for shipments with crypto, this does give some terminology to give some legal ground rules for that. Right now it's just kind of the Wild West. This does give some legal framework and give some legal enforceability. If you've paid quote unquote money digitally to somebody, this makes sure that the law knows who's entitled to the goods and the money and things like that.
So in essence, it kind of regulates that market within the state of Georgia?
Absolutely. And here's one thing.
As long as it can be regulated, I'm
sure
assuming.
at the port and things like that, if there are transactions done with electronic transactions, this gets to that, and I'll defer to Mr. Powell to elaborate.
Just a minor point on minor clarification. It's not regulation for the sake of regulation like the way you regulate utilities. It's the commercial code, so it's setting the ground rules for buying, selling, borrowing, lending. But it's not out there regulating as a government. This is completely for consensual commercial transactions, setting the ground rules for those, and not providing like government agency regulation.
Okay, that makes sense. Thank you.
Excuse me, can't even talk. Senator Setzler.
This committee has wrestled with the issue of online notary here recently. Does this do anything at all with notarization? That doesn't touch that at all?
No, it doesn't.
That's
and
coming later.
I would have you know, though, Mr. Powell spotted in the bill that it does address security interests relating to agriculture. So since y'all spent about an hour
agricultural
early,
nexus, right?
an hour earlier, just to make it clear, this, you know, the UCC handles business transactions in Georgia, including agribusiness, which is a big part of our economy. So this makes sure if you borrow money, if you lend money, that you're going to have a secure transaction that everybody knows what the law is on it.
Cool. Was this your first time coming to watch this committee, Mr. Powell?
Yes, it's been a pleasure.
Can't imagine what you tell your friends about. When you
I've kept a running list of the topics covered.
It'll be a good topic tomorrow at the firm, I'm sure.
And Mr. Powell's from Parker Hudson, but there were several firms that are on page 3 of your PowerPoint who invested a lot of time in this bill and like to acknowledge their hard work.
Well, I was going to say, stuff like this, you have to have people at the table who practice in this area, and I appreciate you through the state bar doing this so we can make sure we get this right, because I can, no offense to members of this committee, but this is stuff we wouldn't be able to do without y'all bringing it to us. So I appreciate your work on this. Any other questions from the committee? What's the pleasure of the committee? Motion to pass from Senator Setzler. Do we have a second? Second from Senator Hodges. All those in favor of the motion, please raise your hand. It's unanimous. Senator Kennedy, you want to carry this?
Yes, Mr. Chairman.
All right. He likes bills like this. All right. Did he
Thank
tell you
you.
who was going to do this, or I just make that up?
I heard that secondhand.
Okay, there you go. That's what we get for not being here. All right. Thank you.
Thank you.
All right. We have 3 bills left. House Bill 158. Representative Mitchell, come on up. We are working off 481111S, a bill that's going to rename the Stone Mountain Circuit to the DeKalb Circuit. The floor is yours.
Thank you, Chairman Strickland and members of the committee. This truly is, sometimes we bandy about the term simple bill. This truly is a simple bill. What the bill seeks to do is simply change the title of the Stone Mountain Judicial Circuit to the DeKalb County Judicial Circuit. To give you some historical perspective, decades ago, the Stone Mountain Judicial Circuit included 4 different counties. It went from 4 to 3, and now it's just 1 county, DeKalb County. There is some confusion that results as a result of calling it the Stone Mountain Judicial Circuit, in as much as the city of Stone Mountain has its own judicial system. As some of you lawyers may know, citizens have come to the city of Stone Mountain municipal judicial system, as well as mail. Let me just add to you that the clerk of court, the magistrate court, the solicitor, the juvenile court, the state court are all called the DeKalb County Court. And so this simply seeks to put them all on the same line. I might add that when the judges came up here, we originally thought this was going to be local legislation, as it only affects DeKalb County. However, because the judicial circuits are named in the state code, it has to be general legislation.
All right. Any questions from the committee? What's the pleasure of the committee? Motion to pass, Senator Rhett. Is there a second? Second from Senator Setzler. All those in favor of the motion, please raise your hand. It is unanimous. Who's going to carry it?
Minority Chair Elena Parent.
All right, Senator Parent.
Great.
Thank you, Representative.
Thank you so very much.
All right, 2 more. House Bill 327, Representative Cameron. And I believe we heard this bill last year, didn't we?
Yes, sir. Thank you, Mr. Chairman. Yes, this bill passed out of committee last year and went to the floor, but they ran out of time. The bill amends 16622 to include step-grandparent, step-grandchild. There was a case in the Lookout Mountain Judicial District where a young lady moved in with her grandmother and step-grandfather. He took advantage of the situation. After it was discovered, the district attorney's office couldn't find a way to prosecute. The young lady was 17 years of age. So that's where the information came to me, and the bill emanated.
Didn't we hear from the district attorney last year?
The
I
district
believe,
attorney
in committee?
was here last year, and now he's a judge.
Right.
So
he moved on up,
he moved
I guess,
on up.
or depends on how you look at it.
Yeah, yes, sir. So that's the bill in essence.
Question from Senator Setzler.
Mr. Chairman, we've heard this before. It's been through this committee. I'd like to make a motion at the appropriate time.
Now's the appropriate time.
Move to pass.
Motion to pass from Senator Setzler. Keep wanting to call you Representative Setzler for some reason tonight. I don't know why. We have a point of order.
Is that the first time Senator Setzler actually expedited this committee?
It probably is.
Will not be the last. Second.
He likes me.
Yeah. And you just blew it all by taking extra time to make the joke.
Second.
Is there a second? Second. All those in favor of the motion to pass, please say aye. It's unanimous.
Thank you, Mr. Chairman, for your time.
And remind me, is this Senator Payne?
This is Senator Payne.
Senator Payne. Okay.
Thank you very much.
Thank you. All right, Representative New, are you wondering what you did to be punished, to sit and go last?
Hey, I'm just glad to be here.
You have.
I'm glad y'all are here, actually.
House Bill, well, don't speak too soon. House Bill 896. We are working off of LC 570061S. The floor is yours.
Thank you, Chairman. Thank you, members. I appreciate it. I know the day's long. I promise I'll be quick.
This bill would streamline the process for individuals who, after a divorce was final, did not change their last name back to their maiden/birth certificate name. So this would be able to, you would cut costs, time, paperwork for those individuals who simply want to get their identity back. So currently, to go back to your birth certificate name in Georgia, you go to Superior Court. In my county, it starts at $250. Then you run an ad for 4 weeks, which is an additional fee. Then you go back to Superior Court, bring the documentation with you, then you wait for your hearing. I have a friend, it took her over 8 months to go back to her birth certificate maiden name. It shouldn't be that hard. These people just want to get their identity back, and this is a name you've always been associated with. This bill would allow you to petition the Superior Court for the name change. The clerk of court would charge a smaller fee. There would be no publication in the newspaper required, and the judge would be able to, with or without a hearing, change your name back to your birth certificate name. It's cheaper, faster, no ad, and it updates an outdated law. That is the bill. I'll take any questions at this
Thank you for bringing the bill. I told you when I met with you, I think it was earlier today, it's been a long day, but I've had clients that have come back to me because in a divorce case, you can just put your new name in the filing and it's done, and they have to start the process over because they didn't think to do that sometimes. And so I appreciate you bringing the bill.
Thank you.
You have questions, Senator Setzler.
Yes, sir.
I do have a question. Is this limited just to folks who are coming out of a divorce?
It would be anybody that, well, anybody that did not change their name back to their surname after, yes, after a divorce, so yes.
So if someone changed their name for any reason, could they use this to revert back to their root? If for example, if the chair became a rock star and took on this really cool hot name and decided he wanted to revert back to, a simple name like Brian Strickland, could one do that? Or do you have to have gone through a divorce to do that?
Well, this is specifically for, I mean, that was the scope and the intent of the bill, is for the people, women like myself, who kept my divorced name because I had small children.
Yeah.
And so that's a great question.
But yes, it only, my understanding, unless someone corrects me, it only deals with name change in the event of divorce. This is under Title 19, it's 19.5.16, and so it's limited to someone that went through a divorce.
I just asked the question, is there any reason not to make decisions on the fly? Is there any reason you shouldn't be able to revert back to your birth certificate name for any reason with a streamlined process or not? I don't know if there's pros or cons to that.
The states around us have already adopted that. So Alabama and South Carolina have already adopted a faster, streamlined way.
For any purpose or just for divorce?
That is a great question, Senator. I'm not sure. I think it's through divorce.
Okay.
Yes.
I'm not unfriendly to this. I'm just wondering if we could take the whole step and say, hey, if someone wants to revert back.
I think you would have.
I can pick that up next year if you'd like.
You'd have to go to another title. Right now, too, when you petition for a name change, the idea is to make sure someone's not doing it for fraudulent purposes. That's why you put it in the paper. You have to actually appear in court, make sure nobody objects.
Yeah.
And I don't know where you'd have to go in the code to make it broader. Maybe that's something.
Because someone could be trying to avoid some kind of financial accountability or some kind of settlement. So I got you. Okay.
I won't. It's too late to tell the story about a client that brought one of these, and the judge literally said, "I'm not sure what we do if somebody objected. I don't either, judge, because nobody ever objects. We have to go in and actually go in court and make sure no one objects to your name change. Make sure you're not doing it for the event of fraud." But Senator Rett.
Just listening to the senator's line of inquiry, you're not thinking about getting divorced, are you?
I'm not. I hope no one has plans for that either. But no such plans. Sometimes we can kill two birds with one stone, but I did not understand the complexity of this issue, so I'm just trying to understand.
Those were some good questions, because I was wondering, like you did, is this just in a divorce situation, or can you just,
Anything else in the committee?
Speed things along, Mr. Chairman, move to pass.
We have a motion to pass from Senator Setzler and a second from Senator Hatchett. Any discussion? Back to the motion. All those in favor, please say aye. It is unanimous. And who's going to carry the bill?
Anna Vitarte.
Anna Vitarte.
Yes, sir. Thank you so much.
Deborah and Cheryl, thank you all for sticking with us for the whole show tonight. We appreciate it. And with that, we are adjourned. Thank you.